All right, so good morning, and we are back, ready to start panel 2. I am Jen Mascott, professor at Scalia Law School and co-executive director of the Seaboyd and Gray Center for the Study of the Administrative State. And we are so thrilled to be co-hosting this event today with the Heritage Foundation, who's been so gracious to give the facilities, the planning. John Malcolm is just a master of collecting people to talk about what's a really wonderful, important topic today, which is 30 years of Justice Thomas's jurisprudence and his influence moving forward. I'm also a former clerk to Justice Thomas, and I will be resuming a role as his co-professor when he returns to Scalia Law School in the spring. Our second panel this morning is on the justice's role in constitutional liberties, First Amendment, religion, race, and natural law. It's an excellent panel, going to be moderated by Adam Mortara, who I will introduce briefly, and then he will introduce his panelists. So Adam is also a former law clerk to Justice Thomas, and he clerked for Judge Patrick Higginbotham of the U.S. Court of Appeals for the Fifth Circuit. Adam currently is a civil and voting rights trial attorney. He previously served for many years as a partner at Bartlett Beck. He has been appointed 2 times to argue cases in the Supreme Court, and also been appointed to argue in the 11th Circuit, 5th Circuit, and 2nd Circuit, along with a lot of other extensive work as a trial and appellate advocate. He graduated from the University of Chicago undergrad and law school, and my favorite anecdote about Adam, I just learned this morning reviewing his biography, is that between that undergrad and law degree, he snuck in a master's degree in astrophysics in Cambridge. So he is undoubtedly our smartest participant today. Sorry to all the rest of you, also very, very, very smart panelists that we have, and he's going to lead us off in a wonderful discussion. Thank you all so much.
Well, thank you very much, Jen, for that fulsome introduction. It's a pleasure to be back here at Heritage. John stole all the nice things to say about Heritage, so I'll just say the last time that I was here, a very long time ago, was actually for a lunch that featured Justice Thomas as an attendee, this will date me and Jim and Allison. It was the goodbye lunch for Jim and Allison Ho leaving D.C. You might not even know that they ever were here. Judge Jim Ho at one point lived here. My fellow panelists here are Judge Allison Rushing of the Fourth Circuit. They really need no introduction. She's a judge. Professor Nicole Garnett of Notre Dame, also former CT clerk, along with Judge Rushing. And then the only non-CT clerk on our panel, Professor and former Judge Michael McConnell. And down at the end, my brother, Elbert Lynn, partner at Hunton, Andrews, Kurth, and most importantly, the former Solicitor General of the great state of West Virginia, featured so prominently in today's discourse because of their excellent and very, very, very wise senator. So rather than, I'm sure that we'll intersperse some anecdotes about Justice Thomas as we kind of go through the day, and then maybe we'll be asked a question by the press that has nothing to do with the panel discussion at the end when we have time for audience questions. But I want to start off with the topics we're talking about, which are loosely thinking, except for maybe natural law, the list of things you're not supposed to discuss at Thanksgiving. So it's race, religion, and then I guess you're not supposed to exercise your total rights to free speech at Thanksgiving. I never follow any of these rules, so I'm not going to follow them now. Professor McConnell, I want to start off with race, because we can't be on a panel with Professor McConnell without noting that he is widely acknowledged as the foremost originalist defender of Brown against Board of Education. But Justice Thomas, who's probably the foremost proponent of a pure colorblind vision of the Constitution, and he said so many, many times, has not yet made, nor did Justice Scalia make, the originalist case for that view of the Constitution. And I wanted to ask you why you thought that hasn't happened yet.
Well, first, it's customary on these occasions to say how happy we are to be invited to speak, and that's always true, but especially here today because it means I don't have to be wearing a mask when I'm up at the dais. I also, as people have been reminiscing, I can't resist reminiscing that the first time I came to Heritage was while I was law clerking for Justice Brennan, and he gave me special permission to sneak over and hear William Bentley Ball talk about strategies for litigating against abortion. So some things never change, right? But you're asking about about race questions, and it really is quite interesting. It's quite striking how originalism has not played much of a role in the race cases, including, of course, Brown versus Board, where the court asked for re-argument on the question of the legislative history of the 14th Amendment on the question, and then concluded that it didn't have anything to say, something which I think is just, they just didn't look in the right place. But also in the more recent cases, and including Justice Thomas. And if you look at the amicus briefs in the affirmative action cases in the last decade or so, you see usually 2 or 3 fairly serious amicus briefs in support of affirmative action by various parties. And I don't think there has been a serious originalist brief against affirmative action. And then the conservatives have all been consequentialists, and the progressives have, well, mostly been consequentialists too, but at least there's been an originalist contingent among the progressives, and this is a puzzle.
Well, do you think it's because the academy, which is responsible for unearthing all of this history, as you've done so powerfully in connection with Brown, hasn't done its job?
Yeah, I do. I really do think that's the answer, that 14th Amendment or Reconstruction originalism has been slow to take off, but it is roaring today in the academy. I think mostly so far with respect to some other aspects of the 14th Amendment, but there is a great deal there. Take, again, affirmative action. It is a complicated story, but it is not that there's no history bearing on it. It's that there is so much history bearing on it in many complicated ways, especially having to do with the adoption of the Freedmen's Bureau Act, an act which was directed at providing special benefits to the newly freed former slaves of the South. And when, just to give a very quick summary of this, when the legislation was first proposed by the capital R Republicans, the Democrats objected partly on the ground that this was class legislation, meaning discriminatory, because it was directing benefits solely at one racially defined class. Well, the Republicans sort of divided about how to respond, but the actual response was to amend the bill and include loyal refugees, meaning opponents of secession in the South who were also driven from their homes and brutalized by the system, include them in the system of benefits. And so you can see that the opposition to racially based benefits was there at the beginning, but but it's not quite so straightforward as the Constitution is colorblind. In fact, from the other side, the Congress actually had before it and rejected a straightforward colorblindness amendment, draft of the amendment.
So I think we'll come back a little bit to the colorblind concept when we talk about natural law a little bit later. But Nicole, Professor McConnell mentioned a little bit this kind of consequentialist strain, and I've noticed in some of the justices' opinions. I think that this consequential strain, the one that jumps out to me, and I'm not saying it's for the same reason every single time. The one that jumps out to me is the Frederick Douglass quote at the beginning of the Grutter opinion, but there are others. What do you think the justice is doing when he does this? Maybe it's not always the same thing, and I mean, obviously it's a contrast to Justice Scalia, who did that somewhat less. What's going on there?
Okay, first a plug for Notre Dame. Next week we're doing a conference on the the ratification of the Reconstruction Amendments. And there's a really an important new book of documents being published by Kurt Lash at the University of Chicago Press, which I encourage you to take a look at. It is an exciting time to do originalism about that moment, the Reconstruction moment. So consequentialism, I think it's important to point out that there is a distinction between consequentialism and consequences. And when Justice Thomas quotes Frederick Douglass, he does quote Frederick Douglass in Grutter. He says, the famous quote, "Leave us alone." And then he also quotes Frederick Douglass in one of my favorite opinions of Justice Thomas's, which is his concurrence in the voucher case in Zellman, where he says, education means it means freedom, it means light and liberty. And I think he also talks about consequences. Other examples I can think of, in the McDonald case, which is the Second Amendment incorporation case, he talks about really what would mean to disarm poor Black people at the time of the ratification of the 14th Amendment and now. He talks about consequences in Morales versus Chicago, which is the gang loitering case, where he says, I think kind of powerfully, he says that the court can safely say that this is unconstitutional because the members of this court do not live in the neighborhoods where people who are going to suffer from our lofty pronouncements live. And I think those are all, I think in some sense you could call those highlighting of consequences almost like shaming, but not that those consequences are driving his decisions. He is telling, and he does have occasionally, he has never had Justice Scalia's sharp tongue. He never said anybody should put a bag over their head or any of that. But he will say in these cases, interesting cases, particularly race cases, but also cases about average, ordinary Americans who will suffer from mistakes that he believes the court has made. He is not afraid to say, look, y'all don't live in the neighborhoods where these people are going to suffer at the hands of the gangs. And it's not that that's why we should come out the other way, but we came out the wrong way, and we are going to hurt poor people, and we're going to hurt minorities because of our bad decisions. I think that's consequences, and I think it's okay. I don't think it's consequentialism. I think when Judge Jones mentioned sort of his unique voice, his unique role, his story, his unique, honestly, Black voice, it's okay to say to your colleagues on the court and the world, this is a mistake, and this mistake will have terrible consequences for the people that don't have the same amount of privilege that we do. And I think that's the consequences argument, not consequentialism.
And I think maybe what I'm getting at when I say, I think maybe consequentialism is the wrong word. Maybe it's context. It's providing, sort of context for the decision. And the way that you just described it is kind of maybe a better way to think about it. But, one of the ones that constantly comes to mind to me as well is his opinion in Brumfield versus Kane, which is about the murder of Warwick Dunn's mother. And there's a portion of the opinion that was not joined by any other justice where he compares and contrasts the murderer with Warwick Dunn, who, faced with difficult life circumstances, both, Warwick Dunn makes a giant success of himself in college and pro football. What do you think's going on there? Is that just shaming?
Well, it is. It is shaming. So I think, look, I haven't read that opinion in a while, but I think he is, again, pointing out the consequences. That, I think in that particular case, if I remember right, there was sort of a suggestion that perhaps the defendant was in some sense disadvantaged or harmed in some way by the system, and he is saying, let's talk about the consequences of this particular line of reasoning and how it will affect ordinary poor people who are the victims in these cases. Does that opinion go too far? I don't know, but I think it is of a piece of the kind of thing that I'm saying. It's not just about work done. I think some people have said, like, we didn't need the extended autobiography of work done, but it is of a piece of the Morales point, of the Frederick Douglass quotes, like that, look, we are making constitutional errors, and those constitutional errors have consequences. I'm not saying that this guy should get executed because of because I'm being consequentialist. I'm saying that we are making errors that are harming real people, and we need to stop. We need to stop making those errors. We need to return to the proper understanding of the Constitution. And I think that it's really important, this is the last thing I'll say, it's really important to make a distinction between what Justice Thomas is doing when he's talking about consequences and the call for a consequentialist constitutional law on the left and the right. They're not the same thing. It's good to acknowledge that our decisions have consequences. It's bad to say that we should decide what the law is based on what those consequences are.
So, Albert, maybe I misinterpreted your glance over at me, but I thought maybe you had something to say here.
Well, I'll just add one really brief thing, which is I think the justice has always, and he teaches a class with, I now forget because he teaches classes with lots of former clerks, but he does teach a class where he goes, talks about some famous cases and digs into the facts, right, behind them.
Greg Maggs, he's sitting right in front of
Greg.
you.
Yeah, right? And I think he's always shown an interest, both as a personal matter, but also as a jurist, in the fact that cases involve real people, right? That they're not just about the law and the principles that they're deciding. Now, again, I mean, I think, he would be the first to say, make Nicole's point, which is that doesn't drive the outcome, but there's not only nothing wrong with, but I think there's something right about recognizing that, whatever the outcome of the case is as a legal matter is going to affect the actual people who are involved in the case.
So, Albert, shifting to your assigned role on the panel, which is to discuss the First Amendment, could you just orient us a little bit to the Justice's major milestones in the speech area? I mean, there's a lot, but if you could give us a few to touch off on.
Sure, I will. And I want to also thank everyone for having me here. I'm clearly the least qualified on this panel. I thought maybe I was more qualified than Adam, but it turns out he's a literal rocket scientist. So yes, there's a ton to cover in the free speech space, but I'll try to I've got sort of 6 real quick categories to go through. I mean, I think if I were to characterize his speech jurisprudence, I'd say that he's a free speech hawk with perhaps some idiosyncrasies. He's in some ways sort of an absolutist, right? If it's speech, it's protected, but not everything is speech. And that'll get into some, not everything is protected speech. And his cases on kids' speech are particularly relevant to that point. So, I think there's 2 cases for me that I think really stand out as sort of illustrating this principle of him being, a free speech hawk. Reed versus Town of Gilbert, which is the Signs case, where he says, that content-based discrimination based on the basis of content is content-based discrimination, and therefore it is subject to strict scrutiny. And for anyone who practices in the free speech space, I mean, Reed is, whether it is actually a major doctrinal change or not, is certainly being interpreted and treated by lower courts as a huge, potentially huge doctrinal change, in the sense that it says, like, look, if you have to look at the content to decide what something is, whether the law applies, then it's subject to strict scrutiny. And of course, the court has a lot of, little tiny, offshoots for First Amendment, but Reed is very sweeping in its language. The other very recent case that he wrote, this is another majority opinion of his, is the NIFLA case, which is the compelled disclosures for pregnancy centers. And again, I think that's a really good example of sort of how he applies his First Amendment principles. And there he, sort of sweeps away this idea that had been percolating in the lower courts, that sort of speech that, of professionals is somehow specially protected. And a strain, I think, that runs through his speech jurisprudence is the idea that, again, like, if it's protected speech, we shouldn't be having a lot of these sort of separate exceptions, right? That, like, oh, well, if it's this, then maybe we treat it slightly differently. If it's a disclosure versus a required disclosure versus something that is a prohibition on speech, then it's treated differently. He's been very clear that, look, if it's protected speech, it's protected. So those are, I think, the 2 kind of, for me, exemplars. And then, but let me, mention a couple of his, I think maybe what one might consider idiosyncratic rulings. I mentioned the speech rights of children. The Bong Hits for Jesus case, Morse, the violent video games case out of California, Entertainment Merchants, and then the most recent one, he was the sole dissenter in the cheerleader speech case. In all of those, he is sort of, he goes back to the beginning. This is an application of originalism, and he says, look, like, the founders did not understand, kids to have sort of the same speech rights as adults, and certainly in the school context where, you have the doctrine of in loco parentis. Another sort of interesting area, campaign finance and anonymous speech, which I know someone else will get into. He recently, in a concurrence in United States versus Sentencing Smith, which was really not at all about free speech, because it was about the principle of party presentation, which he also really cares about. He wrote a concurrence questioning the whole concept of the overbreadth doctrine, where you can just kind of come in and say, well, it may not really be unconstitutionalized to me, but it sweeps so broadly, there are all these other hypothetical third parties who might be affected that we should strike this down facially. And I'll come back to that. I think there's an interesting observation there about how he really, really, really doesn't like, rules that allow judges to just insert policy judgments, right, and do things on an ad hoc basis. There's obviously a huge one is commercial speech. He does not think that there should be really a doctrine of commercial speech, and I think this gets to his idea of, if it's protected speech, then it should kind of fall under the same bucket. And 44 Liquor Mart is sort of his leading case on that, where he, questions the idea of the Central Hudson test and that it should be subjected to intermediate scrutiny. And then let me just sort of finish with some of these other things where he's sort of recently questioned things. If you've been following, so for those of you who know defamation law, there's a huge case out there, New York Times versus Sullivan, that says that people who are public figures are subject to a higher standard to prove defamation. And the justice has written twice in the last 2 years questioning whether that has an originalist basis, if you really go back to the beginning. And then of course, he recently wrote a separate opinion in the case where they dismissed the sort of Twitter challenge involving President Trump because it was moot, where he sort of questions, how you might analyze Twitter in the First Amendment context. And then I guess the last thing that I do want to throw out there, because this picks up a little bit on this consequences versus consequentialism, is Virginia versus Black. So Virginia versus Black, for those who don't know, is the cross-burning case. There was a Virginia regulation that prohibited cross-burning, criminalized cross-burning with an intent to intimidate, but it included a presumption that cross-burning can be presumed to have an intent to intimidate. And the justice dissented from the idea that that presumption is unconstitutional. And it's a really interesting case because you sort of have to ask yourself, right? And when you read it, you'll see like how much of his own personal background, was percolating through his mind as he decided that case. And it's also an interesting case because I think it's really relevant today in terms of the distinction between hate speech, which is protected because it only conveys a message, versus a true threat, which is not protected. And I think the line between the justice's opinion and the majority there is an interesting one to explore in today's age of sort of, words hurt me and people should be canceled.
So many things to jump off on there. I was in the earlier panel. There was a little bit of a discussion of, Justice Thomas today versus Justice Thomas, say 20 or 30 years ago, and how things have changed. And then at the same time, using moderator's privilege, I asked Judge Rushing to kind of do I don't know if everybody remembers the NFL Films music, the dun 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 dun, to kind of do the thing where Justice Thomas wins. Talk about all the things, and then he was there at the 40-yard line. And so Judge Rushing is going to go through some of the big wins. But when we think about Justice Thomas's big wins, we often conceptualize him as having been right all along, from the beginning, and they're not being changed. So before we get to the NFL films with Judge Rushing, I wanted to ask, and this is maybe a little hobby horse of mine, for all of you, maybe Nicole or Professor McConnell, is there a shift between 44 Liquor Mart and this thing about big tech? Because 44 Liquor Mart, and I know, Professor McConnell, you're a little bit of a dissenter from the idea that he perfectly equates commercial speech with personal speech, but that seems to be a very pro-corporate decision. And now, here we are seeing maybe the corporations don't all have the freedom that they would have had in the 44 Liquor Mart world. It's not exactly the same. It's not speech. What do you think?
So I teach property, and so I read the Twitter, missive. In case you don't know, like last year, Justice Thomas has since the beginning had a practice of saying, in an appropriate case, I would reconsider all of American law. I would reconsider Calder versus Bull, and that maybe paper money is unconstitutional. If it ever comes up, I will write an opinion about paper money even longer than the dissent in the term limits case. But so he does this a lot in dissents from denial and cert and opinions respecting the denial of cert, which I have come to understand from my judge friends are now called dissentals, which was something that didn't exist when I was a law clerk, but I never heard this dissental thing. But if you really want to get a sense about what the man's thinking about, it's really fun just to go through a term and read everything that he's said. We should reconsider the takings clause. So he had this little dissental in the case about Trump getting kicked off Twitter, and he said it was moot. He agreed it was moot, but he said, well, maybe these big social media conglomerates are public accommodations or common carriers. Now, as a property law person, I probably read that a little bit differently than as a speech case. So they're platforms for speech, but the question about when you teach public accommodation and common carrier law and property, which I do, it was always it was a traditional exception to the right to exclude. So the idea of a common carrier was you had to accept all comers for a purpose. I mean, if you're the telegraph company, you couldn't decide that you don't like Jim Ho's opinions, and so therefore he couldn't send a telegraph.
A lot of people don't like Jim Ho's opinions, but none of them are here.
So, and the telegraph company, because he was a common carrier, basically the common carrier regulations allowed, were basically a way of limiting the telegraph company's right to exclude Jim Ho from sending a telegraph, or the inn couldn't exclude the traveler because they didn't like the traveler. I actually have no idea what the details of those regulations were, although I pretend to once a year in property. But I do think if you think about his question about common carrier and public accommodation, I think the better way to think of it is, rather than regulating speech, it's whether or not the government can limit Twitter or Facebook's right to exclude because it's serving the telegraph company's purpose or the stagecoach company's purpose, the train's purpose, which is getting people or messages from A to B. I have no opinion on that because I really haven't done the work to know what that would look like. But that's how I think about those cases, not like their intention with the commercial speech cases. Because he's not thinking about it as Twitter as the speaker. He's thinking of the Twitter as the carrier of messages. And can Twitter decide it doesn't like message A or messenger A, and therefore, say the president of the United States don't like that person, exclude, or, vaccine misinformation. Can they just decide not to, whatever that is? I mean, I'm vaccinated, but it does, I just want everybody to know. But I mean, whatever that is, can they just decide they don't like the misinformers of vaccine whatevers and exclude it? That seems to me to be what's going on. But Michael might disagree because he's smarter than me.
Well, I'm vaccinated too, by the way. I noticed you sort of moving away. The problem, I think, with treating these platforms as common carriers, let's assume you can do it, okay? But it would not be an all-comers regime because nobody thinks that these companies ought to, allow everything to be said. Everybody's happy when they cut the spam out, right? 80%, I think, of the removals are spam, and there are all kinds of things that they're just. It was okay from the beginning, wasn't it, that Facebook had a policy against adult nudity? It's what makes Facebook different from one of the things that makes it an agreeable, family-oriented thing. But that would be, blatantly unconstitutional if it were a government rule. There's going to be, and the community standards for these companies are just, they're enormously complicated with all kinds of, you can do this, you can't do that, and so forth. And so if they are treated as common carriers, effectively the government embraces each and every one of those things. And the First Amendment kicks in. I think it makes... I don't understand how it is going to work. I mean, just to give a quick example of this from Brown versus Board of Education, that the argument for why common carriers like stagecoaches and railroads could be subjected to desegregation law in the Civil Rights Act of 1875 was precisely because these were common law, common carriers, and that if the government allowed them to exclude a person on the basis of race, that was government action, because only reasonable restrictions would be permitted. And so essentially you get to litigate everything under the Constitution that you would otherwise have litigated under the common law. I don't see how that's going to work for the social media companies.
One
Can I
comment
just
from
follow
Nicole
up
before we
really
get to the
quickly?
highlight
I think
reel.
it's really important when we're talking about this, because this is a panel about, when we're talking about Justice Thomas. Justice Thomas did not say that Twitter was a common carrier, and a lot of his little dissentals, he actually said in a different one this year, he said about regulatory takings, if there is such a thing as regulatory takings, we should say what they are, and if not, we should say that there isn't. But he didn't say that there weren't regulatory takings. I think a lot of these things are just like, I haven't thought that. I think this is an important question that we should explore as an original matter. We haven't done it. So it's, in appropriate cases, he would say, it's time to think about it. I think Gamble is a great example, because I think Justice Thomas thought that the dual sovereignty thing was probably constitutionally problematic, and he says, well, I guess I was wrong, or at least I'm not so sure that I'm wrong that I actually am going to go this far. And I think that is one of the things that's super interesting about him, is that he raises these questions, and he's willing to say, okay, I thought about it, I guess I was wrong. And so just the fact that he said it doesn't mean we're going down the road that Michael just...
And it's as to Albert's point about party presentation, it's a request for briefing, right? When a judge issues I had not heard this word, but I love it, dissentals. When a judge issues something like that and says, in an appropriate case, we might reconsider X, Y, Z, they're asking for the parties to start briefing that issue so that the justices can actually reconsider it as and decide.
And not just the parties, right? I mean, we talked earlier about sort of academia doing the work. Right. I mean, I think in some ways it's a prompt, especially when you're talking about originalism. I mean, the Supreme Court clerks and the justices don't have the time, and probably shouldn't be, just doing it cold themselves. And so because to do it right, it does require a lot of digging, a lot of work. And so it's a prompt to parties, to academia, to lower courts, looking at you, Jim Ho, to start doing the work as well.
And can I just say, I don't think that Clarence Thomas's views on commercial speech in here actually have anything to do with being pro-corporate. 44 Liquor Mart is, I think, an excellent opinion, and I don't read him as saying that that there are no circumstances in which commercial speech is subject to content-based regulation. What he is saying is that the government cannot use corporate speech, commercial speech regulations as a way of regulating primary conduct by individuals. So this was a case in which the underlying purpose of the rule was to try to discourage people from drinking too much. right? It's about using commercial speech to regulate primary behavior. I don't see anything in his jurisprudence that's against regulating, say, false or misleading ads, which, I mean, which that wouldn't be permitted for politics, but it's permitted for commercial speech. He doesn't disagree that commercial speech is important, is different in important ways. But using the regulation of the companies as a backdoor way of regulating people, he thinks should not be allowed.
So one thing that I have in common with Justice Thomas is that we're both fans of the Dallas Cowboys, and that means that as a young man, I had to suffer through the Troy Aikman's rookie season. We went 1-15, but we beat the Redskins on Sunday night. Let's do the highlight reel, because eventually the
That segue.
Cowboys won a bunch of Super Bowls.
So Justice Thomas does have a number of wins over his 30-year career of bringing up issues first by himself and then persuading his colleagues to come along. A number of those wins are not in the topics that we are talking about today. So there's sentencing and increasing mandatory minimums. There's, as Judge Pryor pointed out, the Confrontation Clause. There are a number of wins outside of this area. When we get to talking about religion, there are going to be very few wins for Justice Thomas, especially when it comes to Establishment Clause. But on speech, I can think of two primary situations where the justice first espoused an opinion by himself and raised it for a while, and then the rest of the court came along. One of those is anonymous speech, an anonymous assembly. Since 1995, so very early in his tenure, the justice in separate opinions has reasoned that the text and the history of the First Amendment indicate that it protects the right to speak and assemble anonymously. That was in McIntyre, a case about anonymous leafleting. And then he continued that strain in campaign finance cases in McConnell about forced disclosure of donor identities, and then reiterated that again in Citizens United. In Citizens United, he added examples from the newspapers, from reports of donors whose identities had been revealed pursuant to these requirements, who were being intimidated and harassed. And that goes to the consequences point. He wasn't saying the reason anonymous speech should be protected is because these people are being harassed, but he was pointing it out as this is an example of why the First Amendment cares about anonymous speech. So last term in Americans for Prosperity, the majority of the court embraced Justice Thomas's point of view on anonymous speech, anonymous assembly in that case, and said that the First Amendment does protect the right to speak and assemble anonymously. That was a case where California had a requirement that charities must disclose the identity of their major donors to the state attorney general. And the court held that violated the right to free association. Justice Sotomayor pointed out in her dissent explicitly, she said, this was an opinion that was previously only held by one person, Justice Thomas, and now the majority of my colleagues agree with it. So it probably took a measure of restraint for the justice not to write separately and just kind of take a bow or whatever.
Spiking the football.
Yeah, that would be too far. But it was interesting, I thought, that she specifically noted this change in the views of the majority of the court in response to the justice's decades-long espousal of this position. A related example is in campaign finance. More generally, Buckley versus Vallejo has been, on the justice's, arch enemies list for a long time. He's called, since 1996, I think he's called for the court to overrule Buckley because he doesn't see any difference for constitutional purposes between contributions and expenditures. Of course, the court has not overruled Buckley, but there have been a string of cases where the court has been undermining a number of the rationales for that decision. Within that realm, he's called specifically for the court to overrule Austin, which was a 1990 case where the court had allowed for the idea that corporations and unions can spend more money in expenditures, that is a type of corruption that can be regulated pursuant to the First Amendment. And Justice Thomas has said that is incorrect. That cannot be the case. That is not, to the extent that corruption, and he's never suggested that quid pro quo corruption is not an appropriate reason for the government to regulate speech in these campaign finance cases. But he's consistently called for the court to overrule Austin specifically because just the fact that a corporation or a union had more money and was able to expend significant resources in private expenditures was not the sort of corruption that the First Amendment could regulate. And then, as you know, I assume you all know, in Citizens United, the court did exactly that. They overruled Austin and cited Justice Thomas's reasoning and the reasoning of other justices who had kind of come along on the way. I think another important case in this line of reasoning is McCutcheon from 2014, where the court decided to consider afresh aggregate limits on campaign contributions. So there's base limits, what you can give to an individual candidate, and there's aggregate limits, right, what you can give overall. And in Buckley, the court had upheld both of those, and in McCutcheon, the court said, you know, Buckley, a lot has changed since Buckley in the legislative realm, and Buckley only gave a few, you know, sentences to considering aggregate limits, so we're going to consider it afresh. And I think you see in that opinion the court acknowledging the persuasiveness of Justice Thomas's reasoning about some of the rationales underlying Buckley. He points out in his dissent that there's basically, you know, there's kind of one rationale for Buckley left, and he thinks the court has even given that one up. But I think that's another example where Justice Thomas's persistent drumbeat over decades, writing by himself about an issue that he thinks is trampling core political speech, that's, you know, the center of the First Amendment, of what should be protected and what the founders thought should be protected. And his consistent drumbeat about that has been, you know, persuading colleagues along the way. I'll point out, you know, Justice Kennedy and Justice Scalia obviously, you know, don't get a vote on the current court anymore, but he did persuade the two of them, or the power of his ideas persuaded them that Buckley should be overruled. So that's we've been talking today a little bit about differences between Justice Scalia and Justice Thomas, and Justice Scalia had previously defended Buckley and said, it does not need to be overruled because nothing's wrong with it. And then, you know, Justice Thomas explains why, as a matter of first principles, reasoning from the text and the history of the Constitution, why that's not the case. And eventually, all three of them, Justice Kennedy and Justice Scalia, were signing on to Justice Thomas's opinions about how Buckley should be overruled. So, again, they're not on the current court, but they're, you know, the power of his ideas and his consistency over time has really been, in these two areas, you know, persuading his colleagues. If we move to religion, I think there's maybe one topic that might have some.
So that's exactly where I was going to head. So you alluded to the fact that he hasn't had as many wins in religion.
I disagree.
Oh,
Well, I say an establishment clause.
I
religion.
disagree.
Oh,
Okay,
Nicole, okay.
so what I thought I'd do is actually ask the disagreeer, Nicole, to kind of orient us a little bit for the people that don't know about his views on partial incorporation of the religion clauses, which are unique, or I think fairly said unique, and then maybe hit the highlight reel on the wins, which are more than one according to Professor Garnett.
Well, so first of all, obviously Justice Thomas has very, very interesting and so far he's the only one who has really embraced a particular view of incorporation, which we might want to talk about, which is he doesn't believe in selective incorporation through the Due Process Clause. He's made clear that it's the Privileges or Immunities Clause of the 14th Amendment, and that he's not made clear what the universe of rights apply to the states. All of this, he is in McDonald. He really, it's sort of a historical tour de force about why Slaughterhouse was wrong and why we should reinvigorate it as the method of enforcing rights against the states. He has said, and he hasn't gotten any votes, I don't think he's gotten any votes for his view that the Establishment Clause should not have been incorporated against the states, which he first articulates in Zellman, which is a 2002 case upholding the Cleveland School Voucher Program. But as far as the wins go, I'm a school choice person, so I actually just want to think about this, and Michael is actually a law and religion scholar, he knows more than me, but I want to just sort of march through a victory reel in the school choice thing, where Justice Thomas's views, first articulated by Justice Thomas, I think are the law and there'll be like an exclamation point on them this year. The year I clerked, that he wrote a dissental, although that's not what we call it, in a case that involved a Colorado scholarship that excluded, would not give scholarships to children, to college students who attended pervasively religious colleges, pervasively sectarian colleges. And it involved Colorado Christian University. So he says, first of all, this is discrimination. It violates the free exercise and the religion clauses together, kind of, that to exclude religious institutions from generally available public benefit programs. Then Judge McConnell later has an opinion about this scholarship, invalidating, I think, on these grounds. Then in Zellman, he says, he first articulates this view that Establishment Clause should not be incorporated, but he also starts articulating this view that the Establishment Clause should not be used as a weapon to discriminate against religious institutions. This is one of his consequences piece. Like he says to his dissenting colleagues in Zellman, you want to use the Establishment Clause as a weapon to keep kids, poor kids, out of good schools. That should never happen. And then there's later, obviously, his view that it shouldn't be weaponized, and in fact that the neutrality demanded of the religion clauses read together prohibits the exclusion of religious schools, first articulated in this 1999 dissental, becomes effectively the law in Trinity Lutheran, and then in Espinoza versus Montana, where he repeats again the fact that we should not be weaponizing the Establishment Clause. The Establishment Clause requires neutrality, and it shouldn't be applied to the states at all. And now the court has yet another opportunity to get rid of this nonsense, like Chief Justice view that there might be a distinction between being religious and doing religious things, which I don't understand the status use distinction. But a case the court granted this term asks, can the state of Maine exclude religious schools from a scholarship, a voucher law? And I don't think they took it to affirm the First Circuit. But so I think that is an area where his view that of sort of the Establishment Clause has come to be the law. But Michael might have other thoughts.
All I would say is it goes even before that to at least to his plurality opinion for 4 justices in Mitchell versus Helms. This is a case which I happened to argue, and it had to do with a federal program that provided library books, computers, and some other assistance of that sort to all schools on a per capita basis, so completely neutral program. And the Fifth Circuit held that this was unconstitutional. By the way, not happily. They said that the Supreme Court's jurisprudence was a vast wasteland, and they complained all about how terrible it was, but said they were bound by this. And the court split 3 ways with 4 justices sticking to the old jurisprudence, saying you can't do that. They might be able to use these computers and library books for religious stuff. And Justice O'Connor saying, well, that's not good enough for a facial challenge. Maybe they could, but there's no evidence in this case that they ever did, and so we'll uphold the program. By the way, the practical implication of that is expensive litigation, fact-oriented litigation in every case, right? Because you end up having, discovery and, did they use the computer? Did any of the kids access the Bible or something on their computer? It's like, imagine what that litigation looks like. And Justice Thomas wrote the plurality saying this is okay because this is a completely neutral program. 2 things about it. It was not a consequentialist opinion. It was an originalist opinion that that this idea that aid to the sort of educational social welfare programs of religious institutions is in any way unconstitutional under the, things like Madison's Memorial and Remonstrance is just a misunderstanding, right? And also, and I think this is so interesting, this is the first time the Supreme Court noted that that the discrimination against religious schools is a product of the mid to late 19th century anti-Catholic bigotry. And he takes that on, pointing out that this idea of pervasively sectarian, the word sectarian was code for Catholic. Protestants, by the way, are not sectarians. Did you know that? They're not sectarians because, that's sort of the ordinary set of beliefs. Catholics are sectarian because they believe sectarian stuff like, transubstantiation and, the infallibility of the Pope and I don't know, the Immaculate Conception of Mary. And these are sectarian notions that, unlike Protestants. Right, that was 19th century thinking, and Clarence Thomas was the first justice to point it out. And this was the foundation then of the most recent Espinoza versus Montana decision. So I think this really should be put in his win column.
Can I follow up? One thing that Michael points out that I think another big win for the justice, although it has yet to be articulated. So in Mitchell versus Helms, he says, so in the voucher cases say, well, the reason it's okay to give money to the kids to go to Catholic school or Jewish school or whatever is it's the government is it making the decision? It's the parent. Perfectly logical. But then, of course, the question is, what about when the government is? And he says in Mitchell versus Helms, he says, look, we shouldn't require this circuit breaker. All the Establishment Clause requires is neutrality toward religion. And if you read through the Trinity Lutheran case in Espinoza, I think a majority of the court now embraces that. I mean, in Espinoza, the chief talks about all kinds of programs where it's clear the money was going straight to religious schools, like the mission schools on Native and Indian reservations. And that is groundbreaking. It's huge because you think about all the kinds of, the CARES Act, for example. The CARES Act, tons of direct funding of religious schools, direct funding of churches to keep their employees employed. Nobody raises an Establishment Clause challenge saying, wait a second, there's no circuit breaker. Everybody, they're giving out huge amounts of money. I maybe shouldn't say this because somebody might sue, but I was talking to somebody in New York who said that Jewish day schools are now getting money to pay for science teachers from the state of New York. That actually is a violation of the Lemon Test because as far as I know, that was the exact program at issue in Lemon. And so I think I really do think he's won on these things.
So by design, we left the most limited amount of time for our panel to discuss the role, if any, of natural law in Justice Thomas's jurisprudence. I'm going to ask Judge Rushing to answer that question. But before I do, I have to make the observation that when I read that this was going to be a topic, all I could think of was that I know that you know, that I know that you know, that we know, that Professor McConnell knows, that Judge Rushing knows, that there's this thing called natural law.
You know what I'm talking about.
Judge Rushing, what role, if any, does natural law play in the justice's jurisprudence?
Well, I think Adam's alluding to, there was I don't know if it was a real or imagined fear at the time of the justice's confirmation that he might be consulting some abstract body of natural law to actually decide his cases, right? That in addition to the Constitution and the, U.S. Code and precedent, that he would also, turn aside and say, and now what does natural law say? And that might be the rule of decision. That's obviously not been the case, but he does turn to natural law for understanding and interpreting positive law. I think he wrote about this before he joined the bench, and it has turned out to be the case that in understanding the original public meaning of our founding documents, the justice consults what was informing these principles at the time, and natural law thinking was informing the principles and the philosophies of the Declaration, which he thinks then should be used in interpreting the Constitution, because the Constitution really frames these principles and these ideals that are set out in the Declaration, which are very, very much natural law principles. So where does this actually come up in his jurisprudence? I think there are two that jump out to me, and others probably have many more examples, but his concept of equality as an individual concept of equality rather than a group concept of equality, I think traces to his understanding of the natural law principle of equality at the time of the Declaration, which is then obviously brought into his interpretation of the Constitution. This comes up often in his discussion of the desegregation cases. I think Jenkins is a great example. In racial preferences like Adirond, in affirmative action cases, voting rights. He again comes back to this concept of equality as an individual assessment rather than a group assessment, and he takes that back to the Declaration and to natural law philosophies. Another place that this comes up is in liberty, right? A very capacious term, but he consults. What were the founders meaning when they were talking about liberty in the Constitution and the Declaration? And he interprets that as negative liberty, right? Freedom from government action, freedom from restraint even, perhaps, is its limited meaning, rather than freedom to benefits, freedom to certain rights. He talks about this at length in Obergefell, where he's citing Locke and the other sort of natural law sources for the idea that this was the concept of liberty that he thinks the framers were putting into the Constitution. As Nicole alluded to, the big question in this area is the privileges or immunities clause, and in McDonald, he's acknowledged that he thinks that's where rights, to the extent that they are incorporated, that's where they come. But that there might be, he's said, principles of equality, government by consent, inalienable rights proclaimed in the Declaration. These are all in our Constitution. And so the big question in privileges or immunities is, to what extent would he draw upon natural law to determine what the content of the privileges or immunities are, aside from any rights that are explicitly mentioned in the Constitution.
Any other comments from the panel on the role of natural law in justices' jurisprudence?
After our sort of organizing meeting on this, when I knew this was coming up, I asked my research assistant to go through all of Justice Thomas's opinions for all references to either natural law, natural rights, or the Declaration of Independence.
What fun.
And Judge Rushing is entirely correct. It wasn't just our impression of two. If you read them all, which I did last night, he does not, in any of these, use natural law as a direct basis. He doesn't say natural law says this, therefore, that's a source of authority. In every example, he takes aspects of our Constitution, and he explains what they would have meant in light of the natural law tradition against which they were written. Judge Rushing gave a couple of examples of that. By the way, I think for equality, it's not just individuals versus groups, but I think for 2021, I wish people would think more seriously about what Thomas is saying here, because he insists that the idea is of an equality of rights. Every human being is entitled to the same set of rights, and this is what today is being rejected quite explicitly under the rubric of equity rather than equality. So when you hear the equity versus equality thing being argued. This is precisely what Justice Thomas has been writing about. But he's also applied it as he mines the natural law treatise writers for the definition of executive power. There are quite a few examples of this, and so I think that the idea that he just is going to, treat natural law as sort of an extra constitutional source of legal principles, I think is just not so.
So with that, and speak on behalf of the panel will yield to as many questions as can be contained in a 13-minute period that are actually about the subject of the panel.
And since the panel's on everything.
First of all, thank you so much for speaking today. Kind of on the last issue that was discussed. If I remember correctly, in McDonald versus City of Chicago, I think the biggest question for me at the end is if the incorporation should occur through the Privileges and Immunities Clause. Will those rights apply to non-citizens? And I think Justice Thomas kind of relegates that question to a footnote. But it seems to be the larger question there in light of the natural law and the idea that these rights, these privileges and immunities should apply to everyone equally, regardless of citizenship. How does that pair with his understanding that incorporation should only be applied to citizens of the United States?
I'm going to exempt Judge Rushing from that question and pitch it to Elbert. You argue cases in front of courts and get asked weird questions all the time. Go ahead.
I haven't,
I've given some thought to this.
all right, I will yield to
Judge
Judge
as the questioner indicates, this is a very big, very hard thing because the 14th Amendment refers to the privileges and immunities of citizens of the United States. Right? It is not a natural law principle. Right? The content of the privileges and immunities arises out of, among other things, I don't think exclusively natural rights theory, but it arises mostly out of the common law. Most of the founders believe that common law and natural rights theory were very closely tied, and so the content of the rights has a natural rights basis, but privileges and immunities of citizens of the United States pertains to privileges and immunities of citizens of the United States. Now, that may not answer the whole question because there's also an equal protection clause. And if it is true, as the Supreme Court has held on numerous occasions, that the Equal Protection Clause prohibits discrimination against non-citizens with respect to matters not related specifically to participation in the political community, then it may very well be that once privileges and immunities are protected for citizens, they also, by virtue of equal protection, are protected, that non-citizens are protected. To my knowledge, Justice Thomas hasn't addressed that.
So I have given no thought to your question, but I thought you were going to ask a different question, so I'm going to answer it. So I think the biggest question after McDonald is whether, so I don't think he said, I'm not sure he says that this is incorporation, something else, and whether or not rights not contained in the Bill of Rights are privileges or immunities of citizenship, and if so, what unenumerated rights there are. In his opinion in Sayans versus Roe, he talks about the famous sort of Corfield versus Corrigan, like list, which includes stuff not in the Bill of Rights. So I think that's the really interesting and big question is to what extent are unenumerated rights imposed against the states, and if they are, what they are. And to Allison's point, Judge Rushing's point, I think the natural law thinking of the time would inform those.
Then we'll come over here. Right here first, and then we'll come over here.
Sorry. Thank you for the panel, obviously. I had a question. It sounds like what's being discussed is a natural law canon of construction. And I guess my broad question is, should there be one, and what should it look like? Which I know is a huge question, but...
I don't view it as a canon of construction. I just view it as a part of the historical examination, that when when there's a particular term that comes out of a particular tradition, that looking to that tradition is a way to understand it. I don't think it's any fancier than that. And we know that many of the terms of the Constitution did come out of a natural rights tradition.
In the back over here.
I'm Roger Pilon with the Cato Institute, and I'm going to follow up on that first question and put a question to Mike McConnell, which will afford him an opportunity to give the wrong answer. If the privilege...
We've been doing this for 20 years.
If the Privileges or Immunities Clause provides privileges or immunities for citizens of the United States, it seems to me that therefore it refers back to the rights retained by the people, which will get us back into the natural rights tradition of the Declaration of Independence and afford an opportunity for judges to expatiate on the idea of rights retained by the people and therefore to invoke the common law tradition by way of informing the Ninth Amendment. Would you care to comment, Michael?
So the 14th Amendment needs to be understood as a kind of nationalizing of rights amendment. It came about because of secession. Federalism has a lot to do with it, but not in the usual sense. I'm not saying it's federal. It's not like states' rights. It's the opposite, right? It is an idea that we need to nationalize rights. And so what the 14th Amendment says is that all, citizens of the United States have all the privileges and immunities of citizens of the several states. And then that refers back not to the Ninth Amendment. The language is entirely different. It refers back to the so-called comity clause of the Fourth Amendment, which requires each state to treat citizens of other states equally with respect to privileges and immunities. So what did that mean? This is where Corfield versus Coriell comes in, that there was a uniform body, not quite uniform, but a general body of common law. And if you go through Corfield versus Coriell, it's about the right to own property, to make contracts, to enter and leave, to be subject to the same criminal laws. I may be leaving out a few of Corfield versus Coriell's things. Those are basically, that's the first year law school curriculum. Right, it's common law, and the idea is that when somebody from Massachusetts goes to Pennsylvania has to accord that person all of those same basic privileges and immunities. They can't treat them as aliens. That was the basic idea. And then the 14th Amendment comes on and says, and what's more, states have to treat all of their citizens. Think now of the freedmen, right, who are being denied those rights under the black codes. They have to treat all of their own citizens in the same way. So you can't treat your black citizens as aliens either. Everybody is entitled to that same set of fundamental privileges and immunities on an equal basis. I don't actually think that allows judges to say, well, here's something I think should be a privilege and immunity. I think it's what are the privileges and immunities? That is the long recognized mostly common law based rights. I was once giving a talk on this, and the newspaper that morning had a headline that said something like, "Do people have a right to engage in cloning themselves?" And I began my talk with this because I thought that was so hilarious. Here was something that's not even physically and biologically and scientifically possible that people are claiming a right to do. No, it's the established privileges and immunities, meaning these rights which were widely shared maybe not in their precise details, but widely shared among the states and listed in, that happen to be listed in Corfield, and not just Corfield, there are about 5 or 6 antebellum decisions with a very similar list.
So I think it is important that, sorry, Roger, but I don't think that Justice Thomas would embrace exactly your conception of what his job is. I think he's not a common good originalist, whatever that means. That is to say, he's not looking for the content of the Constitution in the natural law. He's not looking to think up rights that may or may not have existed but are implicit in the idea of liberty. He, I believe, thinks that, to Michael's point, that the natural law may inform the meaning of the positive law, but the rights of the privileges or immunities of citizenship, whatever they are, were fixed at the time the 14th Amendment was ratified, and that they are knowable in some sense. But not, it's not like a free-ranging, what would good law be? What would the natural law be if we could reinterpret it today? I mean, I do think he thinks as informing the positive law, the fixed set of rights, whatever they are. And I don't know what his list would be, but I think that's what how he would articulate it.
One more question from over here, but before that, I want to just insulate Nicole from any criticism. I am also vaccinated and also not a common good originalist.
I care more about one than the other.
Holden? Does this work?
Yes.
Just a couple of quickies on this last matter. Jackson used to cite Charles F. just use on the case of the right to move across state lines, and he said, no, that is a line it's a freedom of apply to all persons, even to resident aliens. And of course, in Bushard, Washington was appealing in Corfield to those rights that would flow out of the very logic of a free government, which I took to be the right to examine the witnesses and see the evidence against oneself, which I take to be simply the rights that would flow from any regime founded on the principles of natural law, government by the consent of the government, the rule of law. Just a quickie, though, on Clarence Thomas on matter of consequences. He would say that these policies of racial preferences could affect a kind of an odium to people who may be suspected of being the affirmative action appointee to this hospital, things like this. But at the same time, it's quite clear that his rejection of racial preferences is a rejection in principle. And that objection would have remained even if everybody were happy. No injuries could emanate from this matter. But on that case, what was it, Reed or Doe, where he spoke about the effects felt by those people whose businesses were destroyed because their contribution to Proposition 8 in California was revealed. By bringing out those chain of happenings, what he's really trying to explain is what serious interest is at stake in NAACP versus Alabama. What serious interest may be engaged in legitimate reason for people to keep in confidentiality certain of their political commitments.
And the question.
Brief comments if you have anything to say in response to Hadley.
Well, I would just say I really agree with that, and I don't think we should label this as consequentialism. One of the jobs of a justice is to write opinions to help educate the American people and remind us all of the reasons behind our constitutional principles. And we don't obey. I think we're ultimately not loyal to the Constitution just because it was written 230 some odd years ago, but because it fundamentally describes the set of rights and duties and organization of a free people. And I think I'm embracing what Hadley has just said, because I think Justice Thomas, and he's not the first, he won't be the last justice, that when writing about positive law principles, brings out examples of why those principles actually are very important to a free people. I think perhaps he's the best on the current court at doing that.
So, Adam, you did a superb job moderating. Please join me in thanking our panelists.